Let me begin with a hard but necessary truth. For at least the last decade, America's civil rights laws have been used not to prohibit discrimination, but to institutionalize it. The modern civil rights regime, both inside and outside of government, has been wielded like a weapon, not to safeguard the equal rights of all citizens, but to engineer a radical new social order built upon the deliberate dispossession of huge swaths of our country. Rather than protecting the constitutional order of the founders, it has become the vanguard of a revolution in the political, legal, social, and even moral underpinnings of American society. The revolution has gone by many names: affirmative action, anti-racism, social justice. Today, it most commonly is referred to as diversity, equity, and inclusion, or DEI. But whatever the name is, in every instance, it amounts to the same thing: a new racial caste system sanctioned and enforced by the administrative state. Americans never voted for any of this. It slunk in through the back door, cloaked in bureaucratic doublespeak and soothing euphemisms. But today, it has wrapped itself around all the great institutions of American life: our schools, our businesses, our government, and even our armed forces. The bureaucracies of this new system are the diversity officers, the human rights commissioners, the HR managers, and select members of the groups at the top of the victim hierarchy. The victims are the rest of America: the smart, working-class kid who can't get a scholarship because of his skin color, the Christian business owner targeted and persecuted for his faith, the patriotic young West Point cadets subjected to mandatory struggle sessions for their toxic masculinity. DEI isn't just illegal, it's a fraudulent and cynical ideology, from top to bottom, built on layers of lies. It's not about diversity, it's about discrimination, a sustained campaign of collective punishment wrapped in the rhetoric of social justice. It's not about equity, it's about retribution. The advocates of DEI don't actually want to level the playing field. They aren't interested in equality under the law. Their entire mission is to elevate members of certain groups over members of other groups and remake America in their own image. And finally, it's not about inclusion. It's about exclusion of the competent, the qualified, the meritorious, and those people are members of the wrong race or sex. In many blue states, DEI is now entrenched at every level of government decision-making. At the federal level, it has produced a vast universe of civil service preferences, taxpayer-funded minority-only grants, and open racial discrimination in contracting. Under the Biden administration, farmers in the Midwest were told they couldn't get debt relief. Restaurants were deemed ineligible for small business grants. And small business owners were barred from lucrative federal contracts, all for the crime of being too male or too white. Much of this took place in the wake of COVID, where years of rolling lockdowns decimated many small businesses and drove countless others to the brink. In the face of all that, the Biden administration redistributed billions of dollars from taxpayers to members of what they deemed to be socially disadvantaged groups, while leaving the rest of America out in the cold. The rest of America, to be clear, refers to the majority of people in this country: our fellow citizens, brothers, sisters, mothers, and fathers, business owners and shift workers, good people who live honestly, work hard, pay their taxes, and expect only a basic standard of fairness from their government in return. Now, let me be even more clear. The only just and legitimate interpretation of our civil rights laws is what their text plainly demands: equal treatment under the law. That means an end to racial preferences, an end to double standards, an end to legal fictions like disparate impact, which treats differences in group outcomes as evidence of group discrimination, a totalitarian logic that demands a total leveling of society to achieve its ends. Our civil rights laws and Reconstruction amendments were created to end a racial caste system, not perpetuate it. Under the leadership of people like Harmeet Dhillon, who's here today, this Justice Department has moved boldly to reassert the principle that civil rights belong to all American citizens, not just a select and favored few. For too long, we allowed the civil rights apparatus to be weaponized against the very rights it was supposed to protect. For too long, the people who ran our government looked the other way, or worse, actively partnered with those who were engaged in outright racial discrimination. Those days are over. Today's hearing is about reaffirming a simple but radical truth: that all Americans are entitled to equal protection of our laws, and that no Americans should be treated as second-class citizens in their own country. As Chief Justice Roberts so eloquently put it, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race.
So today's video is on last week's Senate hearing where Harmeet Dhillon, the Assistant Attorney General for the Civil Rights Division of the DOJ, touches on DEI. The hearing is focused on Trump administration's efforts to eliminate DEI practices in the federal government, educational institutions, and the workplace. I'll be touching on a few points here in this video, but you can find the full hearing down below in the description. I'll leave a link there for you to check out. But yeah, let's hear the opening statement from Harmeet Dhillon and what she's done so far in her first 100 days in office.
On January 21st, President Trump signed Executive Order 14173, titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. The executive order stated that race and sex-based preferences, under the guise of so-called diversity, equity, and inclusion, violate the text and spirit of our long-standing federal civil rights laws. DEI initiatives reflect a set of practices that unlawfully discriminate against, classify, exclude from participation, or deny benefits to individuals based on race, sex, or other prohibited characteristics. The order announced that it is the policy of the United States to protect the civil rights of all Americans against illegal DEI initiatives. Enforcement of that policy is now delegated to me. Just last week, I reached the milestone of my first 100 days in office, and under the leadership of Attorney General Pam Bondi, we have been busy implementing President Trump's bold agenda for ending illegal DEI for all Americans. I will highlight some of our work for you today. Here are some of the ways we have taken steps to end DEI in education. First, as a result of multifaceted investigations into illegal DEI-based discrimination, harassment, and abuse at major so-called elite universities and colleges, the division is now in discussions with many educational institutions to end all unlawful DEI programs throughout these schools, including in their law, medical, nursing, and other specialty disciplines. Second, we are actively investigating several prominent colleges and universities regarding rampant anti-Semitism, resulting in discussions aimed at ending anti-Semitic abuse on college campuses nationwide. Third, starting in April, we opened investigations into 50 major universities, 16 top law schools, and 7 medical schools by sending letters requesting any changes to admissions processes post Students for Fair Admissions versus Harvard. We are also investigating racially discriminatory admissions practices at selective public high schools. Fourth, we are engaged in several lawsuits and investigations into Title IX discrimination against the rights and safety of women and girls in classrooms, athletic fields, dormitories, and other facilities. As a result of our efforts, several institutions have reversed course already. Fifth, we are investigating the University of California for its race and sex-based discriminatory hiring practices under UC's 2030 capacity plan. The Civil Rights Division has also acted in various employment-related matters. First, we are investigating Minnesota's hiring and employment practices. State policies appear to require agencies to engage in illegal race and sex-based hiring in violation of Title VII. Second, we are investigating the Hennepin County Attorney's Office policy that requires race-based decision-making in plea agreements. The investigation is ongoing, though that office has refused to cooperate with our investigation. Third, we're investigating Rhode Island regarding its affirmative action plan that sets race-based hiring goals across its government. In light of Rhode Island's refusal to cooperate, we're assessing our next steps under Title VII. Fourth, we're investigating Chicago's racially discriminatory hiring practices permeating its government. This is just a small fraction of the extensive portfolio of actions we have taken toward ending DEI in my first 100 days in office. Every day, my team assesses new opportunities to combat invidious racial discrimination. From diligently pursuing investigations to drafting and filing federal civil rights lawsuits, the Civil Rights Division strives to protect the civil rights of all Americans against illegal DEI initiatives. While the division's jurisdiction is governed by statute, we work closely with the chair of the EEOC and heads of other executive branch agencies to combat illegal DEI initiatives and to uphold the civil rights of all Americans. With these efforts underway, Senators, the goal is clear. Either DEI will end on its own, or we will kill it.
Either DEI will end on its own, or we will kill it, says Harmeet Dhillon. And she's done a ton of work since being brought on. She's actively battling any DEI initiative that is in clear violations of Titles VII and IX. I'll put those titles up here so that you can give them a read. But basically, Title VII prohibits employment discrimination based on race, color, religion, sex, and national origin. Title IX prohibits discrimination based on sex in education programs and activities that receive federal financial assistance. Now, instead of using his time wisely and asking genuine questions related to what this hearing is about, Senator of Vermont Peter Welch decides to ask who won the 2020 presidential election. Let's give this a listen.
Senator Welch.
Thank you very much. Ms. Dhillon, who won the 2020 election for president?
Senator, I previously testified on this matter. President Biden was declared the winner of that election, and I honor that and respect that.
So, but you can't say he won?
I mean, he was the president for 4 years. He clearly was the president.
Most of us know that. I'm asking if he won.
I've answered your question, Senator.
But you haven't. I want to ask you a question about...
That silence from Harmeet Dhillon was loud. You even hear people in the background just laughing at how stupid that question is. And then he proceeds to ask about Texas redistricting, which still has nothing to do with why they're having this hearing. So his line of questioning is just pointless to go over. But next, we have Senator of Utah Mike Lee with his line of questioning in regards to racial hiring quotas.
Over the course of time in our country, seen that a lot of people have worked really hard for a long time to try to divide our nation along racial lines. Now, history may not repeat itself, but it often rhymes. And in nearly every era of American history, people who have done this perhaps sensing deep down that this is wrong, that it's just fundamentally wrong, try to justify it. And almost invariably, they will couch it in terms of this is better for everyone, in terms that make it sound charitable, kind, it's for everyone's good. That was the case, for example, in Brown versus Board of Education. The defendants in that case, defending their own pattern of de jure racial discrimination, said it's okay because our subjective motivation for doing this is benevolent. It's not malicious. We think this is best for the educational experience. And yet it's wrong. And yet it's also contrary to the direct terms of the Equal Protection Clause of the 14th Amendment. And since then, it's been made doubly illegal. It's been made in violation of a number of federal civil rights laws. Now, one of many more recent modern examples of this attempt to divide American citizens on the basis of race involves the use of disparate impact policies, policies that in many circumstances effectively encourage racial hiring quotas and erode equal opportunity of employment. When you're doing that, you're violating the law. It would seem to me, because you're treating people differently on the basis of race. And that is something that Title VII in the employment context prohibits. How, in your view, has this concept of disparate impact and the use of disparate impact policies undermined equal opportunity in hiring?
Senator, what we've seen, and I've been a civil rights lawyer for over 3 decades now, is that the well-meaning quota-based systems that you described have resulted not in equal opportunity for individuals, but sort of a group form of justice that is more of a Marxist concept, and it is frankly inconsistent with our Enlightenment-inspired constitutional values that guarantee equal opportunity for every individual. And so I think that is really the philosophical difference. If you believe in equality or equity-based outcomes as opposed to individual rights and opportunity, that is where the distinction falls. And our civil rights laws are clear. And as recently as this year, since I've been in office, in the Ames case, the United States Supreme Court has reiterated that every individual is entitled to equal consideration under the law under Title VII and not simply have a higher burden of proof because they happen to be a majority plaintiff.
Dhillon hits it on the nail here. Equal opportunity for every individual. And I've already showed you all in this video what Title VII entails, which prohibits employment discrimination based on race, color, religion, sex, and national origin. So these hiring quotas, where you have to recruit a certain number of people in minority groups, just dishes out merit-based employment. Recruiters have to hit their numbers, and if that means hiring people of color less fit for the position, then they'll send an offer. One example I can think of are the safety issues with airlines. DEI initiatives like the ones explained here compromise merit-based standards, where less qualified individuals in roles such as pilots, mechanics, or air traffic controllers can increase the risk of safety incidents. And we've seen this happen with Alaskan Airlines, United Airlines, and plenty of others. In the next clip, Dhillon actually shares some examples she's seen in regards to employment discrimination.
Well, Senator, you see so many examples of racially exclusive scholarships. You see hiring opportunities or programs in both faculty as well as other staff that require a quote-unquote racially diverse pool at every step of the hiring process that effectively at multiple levels excludes qualified individuals from being able to qualify and compete and get to the end of that process. But you even see today, after all of these civil rights laws and all these Supreme Court precedents, blatantly racist ads from some of these institutions of higher learning soliciting input from so-called disadvantaged minority groups. And these are illegal. You're also seeing in response to Students for Fair Admissions and other cases, video requirements in applications now that bring back the racist attach your photograph to your job application, which allows racial discrimination. So that's something that we need to look at eliminating as well.
We'll now move over to the Senator of California, Adam Schiff. Senator Schiff briefly touches on the SFFA v. Harvard case, in which Harvard's admissions process penalized Asian applicants by holding them to a higher standard compared to other racial groups. The Supreme Court in that case ultimately ruled Harvard and UNC's race-based admissions program as unconstitutional, which there's no argument there. I mean, they were clearly discriminating against Asian American applicants, despite them even having a higher academic performance or scores. Now, I'm gonna play this next clip before I give my opinions on it, but Senator Schiff ties this all back to the University of California and their race-neutral process. But do note, he's talking about the admissions process versus the previous conversation being on the hiring process.
Senator Schiff.
Thank you, Chairman. Ms. Dhillon, you recently announced that DOJ was launching an investigation into the University of California over its UC 2030 capacity plan, which notes that future growth of faculty and students should result in campus populations that better reflect and tap the talent of underrepresented populations, who represent the majority of Californians. In the SFFA versus Harvard opinion, the Supreme Court held that nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise, allowing universities to continue assessing students' experience with race on an individualized basis. In that opinion, in his concurrence, Justice Thomas praised the University of California for achieving diversity through race-neutral policies, including preferences for low-income applicants and first-generation students, and recruiting efforts targeted at areas with substantial populations of people of color. Are the race-neutral policies, like those used by University of California, which Justice Thomas explicitly praised in that opinion, now considered by you to be illegal DEI?
Well, Senator, first of all, the investigation that we've opened is an investigation, and it's an investigation into the hiring policies of the University of California system, not the admissions policies. That said, I have absolutely seen abuses in the admissions policies and using race as a crude proxy for discrimination.
That's the question I asked you. Are the race-neutral policies praised by Justice Thomas now considered by you to be illegal DEI?
I think you're mixing apples and oranges.
Well,
I can't really answer your question.
you can answer my question and say, yes, they are now illegal. That is what Justice Thomas praised in terms of race-neutral policies, which include preferences for low-income applicants, first-generation students, things like that. Are you now saying that what Justice Thomas praised is now illegal in your view?
Senator, there's a difference between what you see on paper and what you see in reality, and I reject your premise. I reject your premise that how California describes its admissions practices is
about whether you subscribe to the Supreme Court's opinion or whether you disagree with Justice Thomas' concurrence. You can answer that question, can't you?
In the abstract, yes. In reality, what you're describing does not exist in the UC system.
Okay, so Justice Thomas got it wrong. Is that what you're saying?
I'm not saying that.
Well, you are saying that because he was praising the policies of the University of California. You seem to be saying now that any university that gives a preference to low-income applicants is engaged in illegal DEI, or if they put a focus on first-generation students, that's somehow impermissible. After all the years of criticism of cancel culture, you seem to want to cancel any institution that has views that you disagree with.
In the abstract, yes. In reality, no. She subscribes to the ruling of the Supreme Court in that case, but doesn't agree with the University of California and their policies. Now, I can see where Adam Schiff is going with this, and I don't knock him for it. Having preference for low-income or first-generation students isn't necessarily a bad thing, and it's not illegal, but it can be seen as a workaround that prioritizes demographics over merit. And that's what Dhillon is alluding to here. Essentially a mask for discrimination. Now, I think most people believe in DEI on the surface level, but when it's actually implemented and when you take a deeper look into it, it goes against what it was intended for. Going back to the hiring quota, the DEI policies that employers put out is to hire people based on the color of their skin. It doesn't matter if the applicants are less qualified, so long as the company reaches their monthly, quarterly, or yearly targets for how many minorities they have on board. And that's just not right. This last piece has Senator of Missouri, Josh Hawley, bringing up discrimination based on religion by our own government institutions.
Senator Hawley.
Thank you, Mr. Chairman. Ms. Dhillon, good to see you. You're doing a great job. Thanks for being here. I want to ask you about discrimination of a somewhat different kind. That's discrimination on the basis of religion. In the last administration, I'm sure you remember, the FBI issued a memorandum in which it attempted to recruit informants, spies, into Catholic parishes and probably, frankly, other Christian churches on the basis of these churches' theology. They designated and they created a list, an actual list. The United States government created a list of Catholic parishes and groups it did not like, branded them as traditionalist Catholics, I guess that's now a slur, and tried to recruit spies into these churches, which is unbelievable to me. I mean, you talk about a violation of one's civil rights. To my knowledge, that memo has never been formally withdrawn. The Attorney General of the United States at the time, Merrick Garland, sat where you're sitting, first denied it, then attempted to defend it. It is, in fact, totally indefensible. My question to you is, what can be done about discrimination like this by our own governmental institutions? I think one of the things people voted for in electing the current president, who I was proud to support, is they voted to put a stop to that kind of discrimination, to that kind of abuse of our own citizens by our own government. And I just submit to you, of all the abuses of the Biden era, and there were a lot, there's nothing lower than trying to recruit spies into churches to inform on your countrymen because you don't like what's being preached from the pulpit. I mean, this is insane stuff, and they're using the FBI to do it. Can something be done about this to hold accountable the people within the DOJ and the FBI who perpetrated what I frankly think are crimes? I mean, what can we do about this?
So I put up on the screen the case that he's referring to, straight out of the Judiciary Committee's website. Just some wild stuff. I didn't even know this happened. probably because the previous administration withheld the information. You can go check out the rest yourself, but Dhillon's response to Senator Hawley was that this is the most religious-friendly DOJ in U.S. history, and things are happening with this administration to keep states from discriminating against religious groups. They're also in full support for people expressing their First Amendment rights, and open investigations will happen for those violating it, which you love to hear. Ending off, they hit on accountability for people violating First Amendment rights. Let's hear what they have to say.
That's exactly what I think we need to find out. I mean, we need names and dates. We need to know who authored that memo. And those people, their names need to be made public. And if they are still employed, God forbid, at the FBI or the Department of Justice, they need to be fired. I mean, I just think we need some accountability, don't you? I mean, I think if you look at what's happened in the last 4 years, you look at how religious rights were trampled upon. Let's not forget during COVID, who was shut down? Do you remember who was shut down during COVID? The churches, the synagogues. Who was open? Oh, well, the marijuana dispensaries, they were open. Democrat Party donors, all the corporations that gave the Democrat Party, they were all open. But churches, closed. Synagogues, closed. And then to have our own FBI recruiting informants into our churches, it's outrageous. I think we need to know who wrote these memos, who approved them, where were they distributed, and I think people need to be fired for it. And then I think, if possible, they need to be prosecuted for it. Don't you think? I mean, don't you think it's time for some accountability? I think we've got to turn the page and do better, sure, but we've got to hold accountable the people who did this in the first instance, or they'll just do it again.
Well,
They'll just do it again.
Senator, I agree with you. I mean, I was privileged to win between my law firm and my nonprofit 3 cases at the United States Supreme Court during COVID to protect the rights of Christians to be able to pray in my state of California. And the governor is still the governor, and there has been no accountability in that state for the gross violations of every person's right of faith. And so I hope that voters ultimately hold the elected leaders accountable, but certainly people who grossly violated the First Amendment those are names I'd like to know, and we will look into that as a result of.
This is my last name, Mr. Chairman, and I thank you for holding this hearing. I just think that you're right about voters, and voters did vote for a change in November. They voted for accountability, and now we've got to give it to them. And I just want to, I know you're not in charge of the FBI, but I just want to send a clear message to everybody who is. There has got to be some accountability for what has happened with our government. There has got to be accountability for how it was abused. And religious believers were abused in the last 4 years, over and over and over. And we've talked about it, and we've held hearings on it, and now it's time to do something about it. And the people who perpetrated these outrageous abuses of our First Amendment rights, they need to be held accountable. They need to be held accountable, and they need to be held accountable as soon as possible. Thank you, Mr. Chairman.
So that's all from the Assistant Attorney General, Harmeet Dhillon, in this hearing. They bring on 2 other people to testify, but I really just wanted to touch on Dhillon's piece here. Felt like she laid a great foundation for, looking into DEI and possibly dismantling it. But if you want to hear the full hearing, again, I'll leave a link down in the description for you to check out. They go more into liability, civil rights division, and septic tanks, and how Biden, get this, under the Biden administration, part of their DEI policies was race-based organ transplant prioritization. Absolutely wild stuff. I definitely would check that out. Let me know how you feel about DEI and whether it should be broken down or not. Again, I don't know shit about fuck, but I can always give my 2 cents, and so can you down in the comments. So, yeah, you guys have a great one, and take care.